Good morning, students. Please note that the class will start shortly. Please give us a few minutes and the class will start. Thank you.
Thank you, Mapula. I think my speakers were off, and I was here since 2:30. So I would like to say good afternoon to students. We welcome you to the discussion class, and I would also like to inform you that for purposes of legality, this discussion class is recorded so that everybody who is in here gives us their consent to be recorded. And my name is Mrs. Mutapo. I am one of your lecturers. I am not alone. I am here with Mrs. Mukabela, and this is our second discussion class. The first discussion class was held last week on Monday. I just forgot the date. The discussion recordings have been uploaded on my UNICEF and also on yours too. The slides that were used for the previous class are also available on my UNICEF for you to access them there. And yeah, so I just need somebody to type for me in the chat if I am clear. Sure. Okay, I see that the recordings is not clear, but I need an indication now to tell me if I am clear currently.
Yes, currently it's clear.
Okay, because I'm seeing in the chat they're saying it's not clear, but perhaps it will get better. And so, like we have said, this is not a class. I'm not here to offer a lecture. Here, discussion. How I will one aspect of what I'm going to talk to you about, and then I will allow for questions thereafter. So I will be looking at the. Wait. Just bear with me. I am trying to share the slide for the class. I'm not sure if I'm still in the class. It's a learning curve.
Yes, you are still in the class, but the recording is very bad again. Like it's
From
not
my
clear.
side.
Yes, from your side.
Yeah, okay. I will. Let me just try and get a headset. Perhaps the recording will be clearer. Just give me a moment.
Okay, thank you.
Mapula. Hello.
Yes, Miss Mutabo.
Am I audible now?
Yes, you are.
Thank you.
And we are also able to see what you are sharing, your screen.
Is it available already?
Yes, we can
And
see.
it's a wrong thing.
Yes,
I
it's
need
incorrect
to
slide.
unshare it.
You can
Unshare it, and how do I
you
unshare
click
it?
on please click on the share button again, and then you'll be able to unshare from the share button.
Mm. Please bear with me. I am trying to unshare, but I cannot see the unshare button. Yeah, it's a challenge from my side. Just bear with me. Yes, I will find what I need to share. I'm not able to see. Mapula.
Yes, Miss
Miss
Mutabo. Can
Tabela.
I share the document for you?
Able to see? Yeah, please do.
Okay, I'll do that.
Yeah, thank you. And can you also tell me if you're able to see it from your side, what I have shared?
Is it you who shared the screen, or is it me?
I don't know, but I'm seeing
Okay, no, yes,
the
it's the
correct.
correct document.
Yeah, okay.
Yes.
And how do I control it?
There's an arrow where you navigate to the side. You see, I've navigated one slide, and again I'm doing that. So let me go back. Or should I control the slides for you?
Please do.
Okay, we are on the first slide now. And then I'll mute my mic, and then you'll tell me when to go to the next slide.
Okay, so I am unable to see the screen with the shared document right now. So if maybe perhaps you can reshare again.
Is it now showing?
No.
Okay, let me reshare.
Sorry.
It's still loading.
Mapula,
Yes.
I think it's okay. I will just continue with the discussion until maybe technology favors us, because now I think we are going to take long trying to share the
Miss Matapo,
how it
on
will
the
be made
chat.
available after the class to the students.
Oh, sorry. On the chat, they are able to see the shared screen.
But it's going to be a problem for us to work on the shared screen because we wouldn't know where we are. So hence I'm saying perhaps for now I will just do the presentation, and then we will share the slide after the discussion. What do you think? Because you cannot see the screen, and you are also unable to see the screen, and I believe whatever they are seeing is only the first page of the slide.
Oh, okay. Okay, it's fine.
Yes.
Thank you.
Yes. This is my laptop. I will be dealing with from study unit 3 up to study unit 9 in the study guide, and also I would like you to also have your tutorial letter 102 in front of you. And I would also like to reiterate that we are using the civil procedure, a practical guide textbook, and we are not using the ebook, because I have seen that a lot of students are using the ebook, and as such, I think we missed pages from the ebook and the printed version that we use. So we will also look into that at a later stage, but for now we'll be making reference to the printed version of the textbook. Okay. So the overview, I will be looking at the study unit 3, which is mainly talking about civil procedure and context, and then I will look at study unit 4, which will also be talking about the structure of our court system, obviously looking into it with regards to civil procedural side. I will look on at the overview of jurisdictional grounds, and from there we'll move to the High Court jurisdiction. And I believe thereafter we will then take questions. We will unmute all and take questions. But in the meantime, while I am busy, you are able to also post your question on the chat so that we do not miss any. And we have the continental system, and the Anglo-American system, which means the parties are dominant in that system, and obviously the judicial officer plays a passive role. And in South Africa, all the courts are following the system of Anglo-American system, except in the small claims court. This is it's in study guide in the study unit 3. If you look at study unit 3.1, it is also self-explanatory there. And obviously, we also have the continental system, which is also of the inquisitorial nature. When we say it's inquisitorial, we are referring to the judicial officer playing the active role in assisting the litigants. So, in that instance, in the small claims court, because legal representative is not allowed, the judicial officer is allowed to assist the litigant in the. And obviously, we follow the civil procedure in South Africa is underlined by the principle of bilaterally party prosecution and party prosecution that is stipulated also in study unit 3.1. You just read at them; they're also self-explanatory. And from there, we have the alternative dispute resolution. It's also in study unit 3.5, and obviously the textbook that I have made reference to, it's, you look at it in pages number 503. It's self-explanatory. When we are talking about alternative dispute resolution, we are talking about the resolution that is not of litigious way. So we have now recently introduced to our system the court annexed mediation. It was first introduced in 2011 in the magistrate court and has since been adopted and regulated in 2014. So if you look at magistrate court rule 72 to 82, they are all making reference to court annexed mediation. And then recently now, the High Court has also introduced the court annexed mediation, and it is been amended or regulated in terms of Rule 41A of the Uniform Court Rules. And we also have the dispute resolution in African customary law. This is obviously talking to what we call transformative action. So we are also trying to transform the legal system. It is also stipulated in study unit 3.6. And obviously, because in South Africa we have different cultures, that's why the traditional court bill has since been a bill, I don't know for how long, because we look into the living law and the custom followed by each traditional thing. So that's why we are still unable to pass the bill into law. But yeah, we're looking at that as well in terms of one of the dispute resolution in civil procedure. And we also have selected legislation.
There's no sound at all from your side.
Hello, am I audible now?
Yes, you are. Thank you.
Oh, are you able to indicate to me when was I no longer audible so that I can go back to those points?
Yes, I will from my side, and also I'll look at the chats.
Okay.
Mutapo, there is a very disturbing sound coming from your side.
I'm gonna go out and try and rejoin.
Okay, thank you.
Hi, hello, Miss Mukavela, can you hear me?
Yes, you are clear now. Far much better.
Yeah, I've just decided to join from my phone because the PC that I'm using, it seems to be giving me problems. So I'm gonna ask you to control the slide.
Okay.
And I see from the chat that I completely went off when I was dealing with alternative dispute resolution.
Yes. And your sound is very clear now.
Okay.
Thanks.
And I was saying, with regards to alternative dispute resolution, we have them in study units 3.5. They are self-explanatory. They were introduced into the civil proceedings as way of alternating resolving matters not using the mainstream of litigation. So students are encouraged to look at those characteristics of alternative dispute resolutions, and obviously to also look at pages number 503 in the textbook, and also that we also are have been introduced to the African dispute resolution mechanism in African customary law. And I had also said that is also in study unit 3.6. And I was also saying the reason it is now included in our discussion is because of the transformation system. And I was also making reference to say that we still have the traditional court bill, which has not yet been made law. And I was saying the reason is because of the different cultures that are employed within the African custom. So mostly we follow our living law according to the custom or the tradition that we find ourselves in. So that is also delaying the bill to be made law, but it also follows the system of mediation and negotiation. So students are encouraged to go and refer in study unit 3.6. We do not have pages in the textbook. And Mapula, can you please just scroll down for me to selected legislation? Thank you. So obviously, with every law in South Africa, they must all be in line with the Constitution. So civil procedure, for us to apply it, we need to take into account the application of Section 8 of the Bill of Rights. We look at the equality clause, that's why it's between two parties, freedom of security, property rights, look at access to houses, and obviously access to court, which has now been made in terms of the development of small claims court. I will talk about small claim court when we move on, but obviously the issue of access to court, it is in line with Section 34 of the Constitution, and obviously every right in the Constitution, obviously the Bill of Rights, it's also limited under Section 36 of the Constitution. So this provision of the Constitution with regards to civil procedure, it is in study unit 3.7. And obviously you can also look at page 13 to 15 of the Constitution, of the textbook. You can move to the next slide. And we have eviction, which also are relevant in civil procedure, and that is stipulated in obviously study unit 3.27. It is also giving us the distinction on how eviction are instituted, but they are instituted with regards to the act that gives them for them to be, it's legislated. So
We are unable to hear you again, Ms. Mutabo.
are you able to hear me now?
Yes, we can. Thank you.
Yes, I had just paused a bit to breathe. I've been talking for a while, so I also need to take a pause in there and there. And obviously you can move for me to arrest. Next slide, please. So previously we had a situation where if people were unable to perform with regards to their obligations, they were arrested in order for them to appear to court, and obviously perform as per their obligation, but that is no longer the case. It has been declared unconstitutional, so nobody is supposed to be arrested with regards to an obligation. So we do no longer have what used to be called arrest tanquat suspectus de fuga, has been declared unconstitutional. And can move to the next slide. And we all now have National Credit Act. It is and the act regulates the lending of money between consumers and borrowers. So according to the National Credit Act, there is a way in which disputes relating to NCA are supposed to be brought to court. So normally we'll have to look at the act with regards to how service on delivery of documents were effected, and before summons can be instituted. You can move to the next slide for me. And we recently have the Legal Practice Act, which was initially the Tennis Act. It has been repealed because we are now regulated by the Legal Practice Act. So it regulates the way in which legal practitioners conduct themselves. The aim was also to just bring to the attention the differentiation that was then between the advocates and the attorneys. So look at that act and obviously make reference to tutorial letter 102 with regards to the aim and of the LPC. You can move to the next slide. Now we move to study unit 4, which make reference to structures of the court in South Africa. So we have the Constitutional Court, which is now the apex court in all matters. Previously, it used to be the apex court in only constitutional matters. Students are encouraged to look at section 167, which speaks to the exclusive jurisdiction of the Constitutional Court, and where the issue of how it can be a court of first instance and when it can be approached directly. You can move to the next slide for me. And we have the Supreme Court of Appeal. This is a court of appeal, so it can never be a first instant court. So it only deals with matters that have been heard in the High Court for appeal, and it does not entertain labor and competition matters because those have the forums in which they can be entertained. We have labor courts and labor appeal court, as well as the competition commission for competitional matters. So a further appeal from the Supreme Court of Appeal goes to the Constitutional Court. And as I have said, it can never be approached directly because it's purely an appeal court. You can move to the next slide for me. And the High Court, it is a court of first instance in other matters, and it serves as an appeal from the magistrate court decision. The appeal, you can refer to section 16 to 19 of the Superior Court Act, which was promulgated in 2013. It hears any matters which is not prohibited by the Constitution or the Parliament. It has concurrent jurisdiction with the CC, and it is also regulated by common law and statute. So with regards to statute, we make reference to section 21 subsection 1 of the Superior Court. It regulates the court. You can move to the next slide for me. And we also have magistrate court. They are mostly referred to as the creator of statute, and the reason being that they were formed purely based on those statutes that were created, and they have no jurisdiction, constitutional jurisdiction. So any matter that has to be taken to the Constitution, it must first be taken to appeal in the High Court. Then from there it can go to the Constitutional Court. For this court, we look purely in the Magistrate Court Act and rules, so it does not have common law rules. Can go to the next slide for me. And we also have the small claims court, which are also a creator of statute. They were created by the Small Court Claims Act. The objective was just, as I have mentioned, with regards to Section 34 of the Constitution, it's just for access to court, especially for those limits that is below 20,000 or that are on 20,000. You can move to the next slide for me. So well, now we are going to talk about jurisdiction, and obviously with the first class an overview of the study guide was given, and obviously the systems with regards to civil proceedings on how the proceedings works. So before I can continue to the overview of the jurisdictional grounds, I would also like to say, before we can decide that a matter it's gonna be heard in the for civil matter, we first need to know the nature of the claim, and the nature of the claim will say to us whether the matter will be heard on the basis of action or motion proceedings. And from there we have what we call the value of the claim. The value of the claim determines to us whether the matter goes to either the lower court or the higher court. And obviously jurisdiction is basically follows the defendant in most instances. So jurisdiction never follows a plaintiff. It's always about where the defendant is. So the issue of parties to civil proceedings will be dealt with at a later stage. We can move to the next slide for me. Thank you. So I will be dealing mainly today with the jurisdiction of the Superior Court. So in order for us to be able to say this court will be able to entertain a matter, we need to know whether the court will have jurisdiction. So in all pleadings that are exchanged or affidavits that are exchanged, the issue of jurisdiction is always alleged, because we do not want to litigate in a court that do not have jurisdiction. So in the High Court, in the Superior Court, we have jurisdiction that is by common law grounds or by the Act. As I have mentioned before, that the Superior Court, in this instance, the High Court, is based by the common law grounds or the Act. So we have what we call the rationale domicili, which it says that we look at where the defendant is domiciled or resident. I would like to believe that students have also looked at our tutorial letter 101 that has a definition and explanation of terms in our guide. However, if not, a student can look at Study Unit 6, it has a definition for those terms that we use that are in Latin. And we also have the rationale regestae, which obviously is further stated into Ratione Contractus and Ratione Delicti Commissii. And we also have the principle of ratione recitae, which talks to the jurisdiction of movable and immovable property. So in civil proceedings, what happens is with every questions that is asked, a student is supposed to give the applicable law and apply that to the given facts to effect given answer. So in actual fact, when a question is asking you about jurisdiction of the High Court, we are expecting to see student explaining common law grounds or section or any section in the Superior Court Act. Mapula, can you move to the next slide for me? Can you move to the next slide for me? And I have said the definitions for Latin words are in our tutorial letter 101, so students can just go there and look at the definition for Latin words that are used in the study guide. You can move to the next slide for me. Next slide. Thank you. So with regards to jurisdiction, I spoke about jurisdiction ratione domicile. It's where mostly the defendant is resident or domicile. In the High Court, we are talking about domicile or resident. So where a defendant is domiciled or resident, that court will have jurisdiction based on that. And we have another principle of ratione regestae, which are obviously claims relating to money. So mostly we look at where the cause of action arose. So you'll find that the court that will have jurisdiction might be more than one court. So you might find that in a situation where we entered into a contract, the courts that might have jurisdiction on a matter should a breach of contract happen might be more than one court, especially high court. We might litigate in a court where the contract was entered into. We might litigate also in a court where performance was supposed to happen. There might also be jurisdiction where breach of contract occurred. So that's why I'm saying with regards to that, 3 courts may have jurisdiction. So a plaintiff has a right to choose in this regard which court will they litigate in. And now I will move to an issue of ratione commissii delicti. It also speaks to where the cause of action occurred. I think I am talking far beyond my slide, but it's okay. So it can also, jurisdiction in the Superior Court is not limited to only one court. Hence, we say we look at where the defendant is. With regards to contract issues, we look at the 3 things that I've spoken to, and obviously with regards to where the delict occurred. So we look at where the delict occurred. Let's say if you are coming to Pretoria, coming from the rural areas, from Limpopo, and you are not familiar with Pretoria, and you are involved in a car accident, so the plaintiff will have a choice to either institute the action in Pretoria where the accident happened, which will be the area where the cause of action arose, or they can also decide to litigate in Limpopo High Court where the defendant will be residing. Hence, I'm saying in the High Court, there will always be more than one court which might entertain the matter. And obviously, the amount of jurisdiction that allows matters to go to the High Court, there must be beyond 400,000. And we have a situation where we deal with foreign Peregrines and Peregrines. So I always say when we talk about a foreign Peregrine, the word in the name in itself, it's just saying you are a foreign in a country. So if you were to move from South Africa and go to Egypt, you are a foreigner in that country. So what happens if you were to become a defendant in a matter, but we bring it here, we'll say somebody from Egypt in South Africa, it's a foreign Peregrine. So what it is now in study unit 8.3, we have the principles of attachment ad fundandum and attachment ad confirmandum. They apply only when the defendant is a foreign Peregrine. Foreign Peregrine is where the defendant is not a resident or is not domiciled within the Republic. So hence I'm saying I take it with the literal meaning to say that if I were to travel to another country, I am a foreigner in that country. So the laws that will apply to the people in that country will definitely not apply to me. So in these instances, we are saying, how do we then secure performance or liability for those people that are not South African residents, but it has nothing to do with citizenship. You might be a citizen of another country. This only has to do with where you are residing or where you are domiciled. So the principle of attachment ad fundandum applies when the defendant is a foreign Peregrine. What happens is then they had decided that the jurisdiction of the court will be where the plaintiff is an in-caller. When I started with the discussion, I had said jurisdiction always follows the defendant. However, in this situation, they had then decided to say we will look at the resident of the defendant. Of the plaintiff. So from there, we'll look at whether the defendant has property in the court which we can attach to secure that performance, because the court does not want to issue an order which cannot be satisfied. So this is just to say that if you get into any form of transaction with a defendant who is not a South African resident, you can also be protected. So with regards to attachment ad fundandum, we look at where the plaintiff is a resident or is an in-caller. And then from there, we look at whether the defendant has properties in the Republic which can be attached to secure performance of the court order. And if there is no property that can be attached, then obviously the process of litigation will have to now follow the defendant where the defendant resides, which will now in this situation be in another country. So we also have attachment ad conferendum. Attachment ad conferendum looks at where the cause of action has arose, because at some instances you might find that the plaintiff is also not an in-caller or does not reside in that area. Let's say in this instance, an example will be if I were to go to Cape Town for a conference, and when we are in Cape Town for a conference, people from abroad are also there in a conference and something happens. So at the end of the day, I am not an in-caller. I am not a Cape Town is not my resident or my domicilium. However, I, as a plaintiff, I am an in-caller of the Republic. So in these instances, then we are going to look at where the cause of action has arose, which in this instant will be in Cape Town, where whatever action would have happened. And then we'll also look at the issue of attachment, whether the defendant has any property within the Cape Town area which can be attached to confirm jurisdiction. So these principles only applies where the defendant is a foreign peregrines. So students are referred to study unit 8.3 and study unit 8.4 with regards to these principles of attachment. So we also have the effect of section 21 subsection 1, section 21 subsection 3. It is talking to the principle of attachment. So students are encouraged to look at that section as to how is it applying to these issues. You can move to the next slide. And obviously, I'm also making an appeal that we also look at Section 28 of the Superior Court Act, and obviously the Section 42 of the Superior Court Act. It is talking about processes of the court. You can move to the next slide. And we move to an issue of submission. So when we talk about submission to jurisdiction, we are talking about giving consent to a specific court, which would normally not have jurisdiction, but you give consent for that court to have jurisdiction. So we're looking at who can submit to a court's jurisdiction. And we are going to say if the defendant is an in-caller of the Republic, they cannot submit to any jurisdiction because jurisdiction will follow where they are resident or where they are domiciled. So local peregrines can also submit to a court if, for instance, with a scenario that I have just mentioned of me being in Cape Town, by this time I get into a squabble with somebody who is also within the South African, it's an in-caller of South Africa. We can agree to litigate in Pretoria for my sake. We can submit there. And then when it comes to the issue of foreign peregriners, we can submit. However, submission can never take place after an order of attachment ad fundandum or ad confirmandum has been issued. So submission needs to happen before the attachment principles. You can move to the next slide. And we move to jurisdiction with regards to property. So with regards to property, we have immovable and movable property. So with regards to immovable property, we have a common law rule which is called forum rei citae. It means that if a matter is involving an immovable property, I would like to assume that all of us in this class, we are familiar with the word immovable property. So the court where the property is situation have exclusive jurisdiction. It's unlike with the other situation where I was making reference to 2 or 3 court having jurisdiction with the matter. Here the court where the immovable property is situation have exclusive jurisdiction. And here it does not matter whether the defendant is an in-caller or is a peregrines of the Republic, because the only thing that we'll be looking at here is the property, the immovable property that we'll be litigating on. You can move to the next slide for me. And we also have the issue of movable property. I'm also making assumption that we all know the difference between movable and immovable property. So at this moment, it's still a debate whether forum racitae follow movable property, because movable property can move from one place to another. So we normally would look at where the owner of the property is. So we apply forum domicile. If I'm residing in Pretoria and I have a car in Pretoria and they want to repossess it, they will always come to where the car is. So students are encouraged to know the difference between movable and immovable corporeals in order for them to be able to tell whether it's a forum racitae exclusive jurisdiction or whether it's a debatable issue, whether it's a forum racitae or forum domicile. You can move to the next slide for me. I have come to the end of this discussion with regards to jurisdiction overview, and I am now going to give comments with regards to assignments on how we would like assignments to be addressed. And like I have said, in most instances we have seen is that student, even after we have made or published commentary with regards to assignment, they do not read. With regards to the discussion that I have said, I was talking to jurisdiction in the Superior Court, which I have said we look at common law rules or the Superior Court Acts. In most instances, what we have seen in the past is students are unable to distinguish between the jurisdiction in the lower court and the jurisdiction in the higher superior court. So I would like to caution students on that. That's why in today's class, I decided to stick to jurisdiction of the superior court so that we have an understanding going forward. We can move to the next slide for me. And the most important thing when you are in a third year module in UNISA, we tend to assume that a lot of things it's known. So when students are answering questions in the assignment, we expect them to give us a law, the applicable law, and apply the law to the given facts, and thereafter give us a conclusion. So we tend to not award marks if we are asking as a question whether the court will have a jurisdiction with regards to a matter and a student writes yes or no, because we are assuming that those things were taught at the lower level on how to respond to questions. So normally we prefer that the applicable law, I always say either the applicable law, the applicable rule, the applicable section, whatever it's a source, your source of reference. and then you can apply your source of reference to the set of facts that is given, and then from there you can give a conclusion whether a yes or a no. So that's the other thing that I wanted to talk about, and also to say that let's avoid using the principle of the high court in the lower court. We are yet to do the lower court jurisdiction. I have said they are creator of statutes, so obviously the only thing that will apply in there will be the enabling act, which in that instant will be the Magistrate Court Act. You can move to the next slide. I think I have already addressed this issue of how to motivate your answer. You can move to the next slide. And students are advised to refer to tutorial letter 102, because now and then we have a amendment in our law. So it's always advisable that you do not answer with regards to old law, because then we will not be able to award marks. So in this instance, after the study guide was drafted, there had been amendments. That's why we have tutorial letter 102. It speaks to how to respond to questions in civil procedure. It speaks to cases that are applicable in civil procedure. So I'm here encouraging students to look at that tutorial letter. It's available under official study material. You can go to the next slide. I thank you, and now I will be taking questions. Hello?
Yes, I've unmuted their mics. They may proceed.
Okay. Do we have any questions, or are the questions addressed in the chat? I'm using my phone, so it's kind of gonna be difficult for me to look at the chat and look at the screen. Are you able to get questions from the chat for me, Ms. Karen?
Yes, most questions were about the recording, whether it'll be published on MyUnisa and when it will be published on MyUnisa. And some students are having clashes with their classes, their online discussion classes. So they asked if they may be excused, and I've explained that we'll publish the recording and also attach the slides on the PowerPoint slides, either on announcement or under discussions.
Okay.
Thank you.
Hi, ma'am. I've got a question.
Yes, you can ask.
I like how you created the PowerPoint slides. I just wanted to find out if will we be able to get the slides, and where?
Okay, they will be made available on MyUnisa under additional study material.
Okay, thanks a lot, ma'am.
Thank you.
Ms. Mtapo, I don't see any questions regarding the presentation, the content of the presentation. I think you covered a lot, and we've learned a lot from your presentation, and also you've explained clearly for us to understand the material better. So I don't see any further questions on the chat, and it was a wonderful presentation from my side. Despite the technical issues, it's a well put presentation. Thank you.
Thank you. So I will now say, in the absence of any questions, we can end the discussion.
Thank you.
Bye.
Bye.
Thank you so much. It was clear.
Thank
We really
you.
appreciate, ma'am.
Thank you so much. Everything was so clear. Your effort is much appreciated. Thank you.
I think there's a question from Alice Zanele. Oh, no. Sorry, my mistake. Yes, there's a question. There's a hand raised by Alice Zanele Tapolo.
No, sorry, ma'am. I just wanted to say thank you for the lecture. It was quite informative. Really appreciate that.
Thank you.
Thank you very much for the lecture. So if I may ask, when will we have another session, please?
Oh, yes. Is it Mr. Tenga? The next class will be announced on my UNISA, hopefully in a week or so.
Thank you.
Thank you.